Hello and welcome to today's Bloomberg BNA webinar. I have just a couple of announcements before we begin. First of all, thank you for attending today's presentation. Questions will not be submitted by telephone. Questions may be submitted at any time via the Q&A pod at the lower right of your screen. Simply type your question and click the icon to the right to submit. Questions will be allowed to accumulate and will be addressed towards the end of the presentation. You will currently see instructions on how to earn credits for attending today's webinar. If you have any questions about continuing education credits, please email us at credits@bna.com. In order to obtain CLE, HRCI, SHRM, and RCH credits for attending today's presentation, you must answer all polling questions that are presented throughout the webinar. There is no submit button for multiple choice questions. If you would like to receive CLE credits for attending today's presentation, please make sure to answer the polling question at the end of the program accurately, which will ask for the jurisdiction where you wish to receive credit and your corresponding bar number. Your certificates will be ready to download in your classroom at learning.bna.com in the My Certificates tab, generally within 1 business day of the presentation. A copy of the presentation you're about to see, as well as instructions for downloading your certificate, can be found in the Files pod to the right of your screen. We would like to thank Global PEO Services for sponsoring today's program. Global PEO Services helps companies hire employees fast without having to set up legal entities in foreign countries. With GPS, you can hire employees in days without having to deal with HR, benefits, payroll, tax, and accounting issues. I would now like to introduce the speakers for today's webinar, Ensuring Compliance with the Global Gig Economy. Nina Markey represents and counsels employers in all aspects of employment and labor law in the single plaintiff and class action context, including discrimination, retaliation and harassment, wrongful termination, wage and hour, unfair competition and trade secret violations, arbitrations, unfair labor practice proceedings, and representation elections. Hazzen Muñoz is Director of Global Talent Contingent Workforce Solutions. In this role, he is responsible for creating a global contingent workforce program at Ecolab. Working in partnership with human resources and procurement, he is contributing to diversifying Ecolab's talent sourcing channels and making Ecolab the premier destination for the world's most capable talent, regardless of their preferred engagement relationship. Adam Sheffield brings 15 years of experience partnering with global organizations on how they can stay focused on their key initiatives. He is a strategically driven business leader who is focused on creating opportunities for organizations in new, emerging, and complex markets. Throughout his career, Adam has excelled in helping clients navigate global workforce complexity by providing HCM insights and analytics. I would now like to turn the presentation over to Mr. Adam Sheffield.
Yes, thank you, Diamond. I appreciate that. And it's an honor to speak with all of you about ensuring compliance with the global gig economy. You know, we think about the gig economy, and that's a term that we're very familiar with if you're in the U.S. The concept's not new. It's been around a long time as far as employees working for certain types of projects or certain types of needs for a short period of time. We're now seeing that to be, many employees are choosing that environment in the U.S. for their employment. What's unique, though, it changes internationally. It's not the same as it is in the U.S., like many things. But you're having, there are some big companies out there like Uber and Lyft that you've read about how they're really challenging the status quo when it comes to the gig economy internationally. And there's some unique factors that are happening globally that I think are important to understand. First of all, the war on talent. I think that we've heard that term for years now. I think it was coined in the late 90s. But it definitely is in play here. You can see this little chart. It talks about the unemployment rate, where it stands. It shows some of the largest economies, the UK and Germany. They're all very low. The United States, it's at one of its lowest points of history. I think it's at the 3rd lowest point it's been in history. So, I mean, it's very difficult if you've ever had to hire just talent in many different fields to be able to fill those jobs that are needed. So what's happening is, because of advances in technology, that there are abilities now to look to hire people not just in your home state or your home country, that you can now find talent across the globe that have the resources that you need, that can connect via the internet and use different tools that are available to them to be able to be a contributing working employee for your organization. So that's changed a lot, and quite frankly, you think of some of the sectors when it comes to the war on talent. Technology sector is one that is absolutely challenged. There's a huge need and demand in that sector, and we're finding high-tech companies are certainly beyond the borders of their current country to find whatever talent they can across the globe. The other thing is, like it says, is global demand. It is unique in history, in human history, when you think about the emerging economies that are starting to have a rising middle class. Just to name a few, you have China, Brazil, and India. I mean, there's billions of people there that are now contributing to the world's economy, and the demand is very, very high. In fact, we had one of our accounts that we've worked with. The poor HR director, almost every other week, she would come into the office, and one of the hiring managers would say, "Hey, we found this person that we want to hire. They have all the skill sets we want. In fact, we've already sent them over an offer letter, and they're in Ireland," or whatever country it might be. And the HR director had to figure out, okay, how do we employ somebody in that country now that they've already been hired, so to speak. And so it puts on extreme challenges and resources for organizations to be able to handle that. When you look at the hiring options internationally, there's really two options. You can hire them as an employee, or you can hire them as a contractor. And we're going to talk a little bit more in depth about the pros and cons of each, that you fully understand. But just under the employee, one of the things is there's two ways to do it under the employee, is to either set up your own branch or subsidiary in a given country, or to reach out to a PEO, or another term that you might hear is employee of record in that country to help support your needs there and hire them as an employee. And then contractor is what it is. It's kind of an independent kind of contractor, and there are some challenges around that. And we'll talk in more depth, but keep in mind that's typically more of a short-term fix, and it might not be compliant in the country you're trying to go in. It is not like the U.S. for sure when it comes to contractors. So it's important to keep those things in mind. So some things to consider as you expand internationally and as you start to look at how you're going to handle these employees internationally. Look at the objectives. What's the purpose of the organization going into that country? Is it sales, research, development? Is there a merger, an acquisition that you need instant infrastructure? How does that look? The other thing is, what's your footprint going to be in that country? Do you have a lot of employees? Do you have a small number of employees? What does the footprint look like? It's important to know what that's going to be. And then what's the speed? How fast do you need to get there? How fast do you need these people to be on board? Do you have incorporation work already done or registrations done? Bank accounts can take a long time. I've spoken with many accounts that have been challenged just to open up bank accounts internationally. It's not as easy as you think. And then what type of employee contracts or templates do you have in place? Do you know what that looks like? What resources do you have? What expertise do you have as far as that goes? And then going on to the fourth piece is, what type of risk are you willing to handle, right? What does it look like? What type of permanent establishment laws might you fall into in that given country based on the activity that you're doing? What are the employment laws you need to be aware of? And then is there any immigration? Is there a work visa that needs to be applied for? All these things need to be understood, and then really compare it to what are the resources that you have in your organization to help support that.
So I'm going to speak to this, the gig economy issue from the perspective of a multinational. Yeah, at Ecolab, we absolutely would agree with Adam's sentiments at the start of the session to speak about the fact that, ultimately this boils down to talent shortages that we are seeing not only here in the U.S. but around the world. There is labor supply changes that are happening around the world due to a number of things, whether it's decreasing birth rates and just an overall aging population. Adam referenced technology shifts in the workforce as well, and those are all creating talent shortages. In addition to that, we also have a change fundamentally in the way that people view the workforce and the way that they would like to work. So, you have basically on two sides of the age spectrum, you have millennials who feel more comfortable with the idea of not necessarily being tied to an employer, but feeling comfortable with the idea that they could pursue opportunities based on the experiences that they can gain. And on the opposite side of the spectrum, you have baby boomers who are considering retirement and looking for ways to continue working that still allows them flexibility to pursue other interests. So from Ecolab's vantage point, we see this purely as a need from a strategic talent sourcing perspective. We simply don't want to take our talent pool and not allow us to fish in the entire pool. So when we look at the gig economy, really it's about trying to maximize the entire population of available talent to us around the world. And then lastly, we also see the speed of change, ever increasing, whether it's due to technology or just simply the marketplace. The volatility in our business cycles seems to be happening quicker and quicker, and so there's a competitive advantage for those organizations that are able to create a workforce that's flexible, that can flex up and flex down based on whether it's a new emerging technology or a new emerging business opportunity. So it's just an imperative when we look at the gig economy, something to embrace. Now with that comes a host of compliance and risk that I'm going to hand it over to Nina to talk more about.
Thanks, Hazzen. So yes, I'm the attorney on the line for the call to talk a little bit more about what you're looking at in terms of a risk analysis from a legal perspective to the extent you're engaging non-traditional employees, both within the U.S. and internationally. And a lot of the same concerns, but very different standards and very different penalties. So these are things that you want to take into account when you're assessing the situation, and not just assume that you have a contract that says this entity is going to assume this liability for this worker, and that's going to be the end of it. It's actually more of a fact-driven analysis, whether you're looking at it in the U.S. or internationally. And we've really seen a proliferation of legislation, case law, all aspects of the legal regulatory environment trying to catch up to this gig economy and trying to provide some additional degree of certainty for employers who need to be able to engage in this non-traditional sphere with workers on an international basis. The legal theory isn't new, this idea of the joint employer doctrine, and that even if you are not the employer of record, you could be liable for what happens to that worker. But this expansive interpretation, particularly under the prior administration and even through today in the case law, is causing this to get a lot more of focus from employers. So at a very basic level, joint employment exists when a person is employed by two or more otherwise separate entities. So it could be a contractor situation, and you've contracted with an independent contractor. It could be the PEO situation where the PEO is the employer of record and you're enlisting their services for that worker. And a variety of other situations dealing with contingent workers. And what you want to be most concerned about is the idea of joint and several liability. A lot of our clients, I'm co-chair of Littler's Contingent Workforce Practice Group, so I deal with a lot of these issues on a daily basis in helping employers assess their risk, and then at the other end of the spectrum, helping employers who've been named in a lawsuit and helping them figure out where their liability fits in that. And I think one of the toughest areas for them to understand is this isn't something that can be resolved easily or quickly once you're in litigation. So you need to be understanding what the facts are on the ground and not just relying on your contracts to the extent you're using non-traditional employees around the world. There's a variety of multi-factor tests. I'm not going to bore all of you with those here, but bottom line for most of those tests is who's exerting the control over the worker's day-to-day activities. And that's in most factors, most tests that are going to determine your liability under various employment statutes. That's going to be the biggest factor. The other one is economic dependence or independence. To the extent you've got a worker, whether they're an independent contractor, employed by a PEO or a staffing company, if that worker is only working for you during that time period and for a longer time period, more than likely, if there's a legal challenge, which is a big if, they're going to be found to be your employee. So you're still going to have to be ready to deal with that potential risk and assess that risk before engaging in the relationship. So why does this matter? You know, what is at risk? Why do you care about, you know, whose employee somebody is going to be for legal purposes? Inside the U.S., it's been pretty clear what the liability is. It's been established. The standards have been changing and broadening, but the liability and what's at risk has been largely the same. You know, everything from back pay and overtime to back Social Security contributions. By and far, the biggest area of liability is when you get into a litigation and there's a determination that somebody should have been classified as your employee and not as a independent contractor or employee of another entity, and you're on the hook for that. If you can also be found by the court to be on the hook for their back pay and their taxes and the benefits, everything you would have given that person had they been your regular employee. So that is by and far the biggest area of liability when you're looking at that. But when you're looking at it internationally, and I'm sorry, for some reason the slides went ahead. When you're looking at it internationally, you're really dealing with a wider array of much stricter penalties. Not only do you have really everything that you can be liable for in the U.S., but I think as Adam alluded to earlier, particularly in the independent contractor arena, many countries have much more hefty fines and much more hefty ramifications should you be improperly classifying somebody as an independent contractor. The idea of misclassification fines, so not just liability should you be sued, but you can be hit with these hefty fines, you know, from the government. So you want to be aware of what those risks are, both inside the U.S. and then to the extent you're assessing, setting up with an employee who is going to be international, what those risks are in that particular country, because they do vary greatly. And we've seen an increase in this to the extent Adam and Hazzen were talking about their clients. We see it from the legal perspective that there's just so much more uncertainty, and it's not something that your typical HR, you know, depending on how many international employees they have, that they're used to dealing with. So talking a little bit about the current climate in the U.S., you know, we are hopeful under the current administration that we're seeing a bringing back of that broadening of joint employment liability. We've seen two withdrawals of guidance from the DOL that essentially found most workers are going to be employees under the FLSA if there's a legal challenge, and there's a presumption that they're an employee, and the same with independent contractors. The current administration, however, in withdrawing that guidance, has signaled that they are not going to be looking to enforce and are not going to be auditing employers in order to regulate that relationship as much. So that is good news, particularly for U.S. operations and even for international, to the extent that you have non-traditional employees that are straddling those geographic boundaries. Another very interesting development that really has surprised the legal community is the Save Local Business Act. That passed the House and, again, surprisingly, was approved in the Committee on Education and Workforce. And this is a piece of legislation specifically seeking to amend the National Labor Relations Act, which applies not only to unionized employees, but gives even non-unionized employees certain rights, and the FLSA, to provide that an entity can only be considered a joint employer if it directly, actually, and immediately directs the essential terms and conditions of employment. So it's a much narrower definition, going back to the definition from years ago that had been broadened under the prior administration, both regulatory-wise and in the case law. So this provides employers with more certainty to the extent you're engaging in these non-traditional employee relationships in the gig economy. They're trying to provide more certainty as to when you will face liability as an employer, despite how the relationship is structured. One area, though, on the other end of the spectrum with the current administration, consistent with the focus on immigration, there's been a specific targeting of the staffing world so more so with contingent staffing than your typical PEO relationship, but that's probably a topic for another day. To the extent that the administration is cracking down on immigration, they have been specifically looking at staffing companies. So this last bullet point here that's in bold, they define it as employers petitioning for H-1B workers who will work off-site in another company or organization's location. So what that means for those of you who are engaging with staffing companies, PEOs, it's all that much more important that you're engaging with a reputable company, a company that you can trust, has its books in order, that has its immigration books in order, that as the employer of record is responsible for that. But to the extent that you can be held liable as a joint employer, it would be prudent, at the very least, to make sure that they have their house in order. And we're seeing more and more our clients actually including in their contracts a provision that would allow them to audit the company that they're working with in order to make sure that that is continuing to stay in order throughout the duration of the relationship. So I'll turn it back over and get a little more of the less legal interpretation.
Thank you, Nina. I appreciate that. This is Adam. I'm speaking once again about the international piece and how that applies. Nina, you're absolutely right. There's no way to completely shelter yourself from risk when you hire these type of employees internationally. What you need to understand, though, is you need to take an assessment and say, okay, what can we do in this country based on what we're trying to set up? And what I mean by that is, for example, let's say you're going to go down the path of setting up a branch. Well, that sounds great, but there might be some limitations on what those employees actually can do in that country based on the way that the branch is set up. Or you might have a challenge around that. So it's important to understand what you can do. And then it's important, just as important to understand what you cannot do. I see a lot of organizations from the U.S. expand internationally that are saying, hey, we'll just, it's kind of a hire at will type of situation. The answer is no. That does not exist outside the United States. And I've seen, organizations trying to hire employees through kind of an offer letter and the employee handbook that exists in the U.S. And again, those things can really keep you out of compliance internationally. It's a policy that you're trying to roll out is U.S.-based policy. So it's important that you understand what you can do in that country and what you can't. And then you consider what are the permanent establishment challenges that might be distribution licenses that you have or need in those countries, which will automatically default you to the fact that you need to set up a subsidiary. There might be inventory needs. You might need to have certain type of and those type of things, which will automatically default into that permanent establishment piece. And there's more to that, but basically we see. Again, anticipating the gaps as you go to these different countries. What's your expertise that you have in-house, right, in your own organization? What is the limit of your current, resources? Do you have the staff that can support HR in those given countries? Do you have the staff that can support payroll in those given countries? Are you going to go to some type of centralized model or a shared service center? Those are things that need to be asked internally on yourself before you move on and expand. And again, when we talked about the different options, we talked about obviously hiring employees for different ways, is through your own branch or subsidiary or through a PEO type of company or independent contractors. So internationally, independent contractors, some things that are on the positive side and some things you need to be aware of, right? So it avoids setting up an entity in that given country. We typically see clients will be wiring money directly to those employees' bank accounts. It typically is a temporary solution within a few months, and that's about it before maybe incorporation's been done or whatever the case might be. There are increased risks here. We need to kind of talk a little bit about some of those that exist, and they are there for sure. It might not be legal in that country. It could limit your talent pool. We talked about the war on talent, and then you go internationally and you try to put somebody under this contractor model. Well, they're not used to it, right? First of all, they're not aware of it because it could be on the fringes of if it's legal or not. So So it could put them in a tough spot, and so they might not want to work in that type of environment. Obviously, the same type of misclassifications happen. The governments are very aware of these type of things. There's different severance payouts that might be negotiated. We did see one client that had gone this way and developed this type of relationship with one of their employees, and they found out that the intellectual property actually ended up being the employees because of the way it was set up. So it opens up a lot of different doors that could be riskier than you first expected. If you go with the PEO model or employee of record, some of the advantages of that are, first of all, the company becomes the employer of record. They're responsible for all the employee contracts and make sure that it's locally compliant in that given country based on the activity. All types of payroll-related taxes and fees and bank accounts and all those things are done by the employer of record, right? What are the statutory benefits in a given country? That's the responsibility of the employer of record. Expense reimbursement, what's expensible, what's considered income in that given country? What are the local laws, not only HR, but labor laws that might happen and can constantly change in that country and that jurisdiction? A lot of different pieces as far as compliance goes that you can utilize the employer of record to help solve, meaning that you can move quickly into that country and you can be 100% compliant from day one. One of the things that's unique too, it provides that opportunity where the employer of record takes on the responsibility of those compliance issues and challenges that come up. They're responsible for all the payroll-related information and those type of things. But at the end of the day, as the client, you're responsible for the day-to-day activity of that employee. Where do they go to work? Who provides them a laptop or what type of equipment they might need? That would be on the client side. So the company culture, your company culture can still be established for those workers in those different countries, even though they're employed by a PEO organization. Nina, maybe you could talk a little bit about some of the risks, understanding those.
Yes, and I think you're highlighting the use of a PEO as the employer of record is so important when you're in that international arena to help you navigate those risks. And that goes to the first point, really having due diligence with respect to your potential business partners. This isn't something like most legal things that you can wing. The penalties, particularly in the international arena, are significant, and you want to be aware of the obligations that you're undertaking by employing and working with somebody in the international arena. And that goes true for both, within the U.S., working with contingent workers and contractors, but also outside of the U.S. And again, you want to look at your agreements and make sure that you're not reserving more control than necessary with respect to terms and conditions of employment. The nice thing about the PEOs is they are the employer of record, and that's very clear, not just in terms of the contract, but also in the factual reality of those things that they have assumed responsibility for with regard to payroll and HR functions. Where you get yourself into more trouble, and again, I don't want to go too much into detail about this, but when you have the non-PEO relationship, more of a temporary staffing or the independent contractor, then you can have a contract, but you're still going to be trying to exert a certain amount of control over that independent contractor, over that contingent worker, and that's going to lead to a finding that you are actually the employer of record. And again, we talked about this a little bit earlier, but you really want to have training and auditing of the on-the-ground practices and supervision. You could have the best intentions, and I think anybody in HR can speak to this, and certainly legal. You can have the best intentions, the best contracts, the best directives. If they aren't being implemented on the ground and you don't have a good sense of what is actually happening on the ground, in this kind of a situation when you're dealing with international workers, then all of your good intentions and all of your good following of the processes and the procedures is for naught. What matters is really what's happening on the ground as well. To the extent that you've got folks, and this is really more looking at when you've got independent contractors and other contingent workers, if you are trying to deflect against the finding that you're a joint employer, you want to watch having those employees or those contractors doing the same exact work that you have regular employees doing, because that begs the question of a court or a regulatory agency, why have you classified this worker as a contingent worker or an independent contractor and not given them the same benefits that you've given your regular employees, such as benefits, health benefits, overtime, and other things. And where we've really seen the legal landscape develop has been, as I think Adam and Hazzen were alluding to earlier, you have the gig economy. Many individual workers, and particularly the millennials, want to be able to work in this more fluid environment, and they want to be able to control their destiny a little bit more. But, the government and the regulatory agencies, and certainly the international governments, don't have the same view. They have their own interests in terms of taxes and other things that benefit them when somebody is classified as an employee. But you shouldn't assume that because the worker wants the relationship to be set up this way, that that's going to get you in the clear. It's still a matter of what the governments and the various regulatory spheres that you're operating within, what those standards set forth. All right, I think I'm going to turn it over to Hazzen.
No, I think it's me again, Nina. This is Adam. So one of the things that you're right, you're exactly right about the governments and the way things are adapting, and we're seeing changes happening. A few years ago, an employer of record services in some of these governments just wasn't allowable. But what's happening is the governments are starting to see that there's kind of an influx of independent contractors, and they're worried about not getting their revenue share, and so governments are making the PEO services available now in those countries to do it properly, so they make sure that they get their fair share of the different wages and taxes and things such as that. A couple of highlights for the PEO services is why you might want to go there. It does broaden the talent pool. We talked about that with the gig economy and the war on talent. It does provide where these employees internationally, they want to work for an employer. They want to have that. You can move fast. You can have infrastructure quickly through, we've helped many companies through mergers and acquisitions, through TSAs type of situations, where like we talked about before about one of our accounts that she finds out after the fact, right, that somebody's been hired in a country that they have no anything in those countries, and so it's able to hire them quickly and to get them on board right away. There is a reduction of risk, right? There's a shared kind of liability piece that Nina's been talking about. So it's not all on your own. That it's taken on by the employer of record. And then it's very flexible, meaning that you might be testing out a new market. We have large organizations that have thousands of employees in some countries, but they'll still use the PEO model in some of their smaller headcount countries because it makes more sense for them. Because they're testing it out. They want to see if that's a country that's viable for them, and then help them make that transition to their own incorporation at some point. When you look at that, speaking of that, you kind of look at, okay, these are two options that, as far as do you set up your own entity or do you go with a PEO route? And kind of the right, this is kind of a little bit of a chart to kind of help you understand. It's first steps, testing a new market, surprise hires like we talked about. Low-term, low-volume employees in that given country. You're not going to you don't want to go in and incorporate in that country for whatever reason. There's definitely an alternative to contractors, so your IP, is still intact. You're not losing that capability. But it makes sense if you're going to, into a country where you're going to have fast growth in that country. You're going to move from, a handful of employees to hundreds of employees. If you have large headcounts, if that's the plan, definitely the entity is the way to go, right? There might be some tax strategy or benefits to incorporate in that given country for whatever reason. And quite frankly, you've outgrown the PEO model. You already have the expertise and support that you have internally that can help support those employees internationally. So it might make sense to move and move on to your own entity and get set up that way. Just again, kind of to reiterate some of the benefits, we talked about hiring days. Again, intellectual property is an important one. Make sure that it's protected. And then, when it doesn't make sense is if you're hiring that large number of employees in a specific country to go down that path, it wouldn't make sense to go down the PEO. And, a good PEO will tell you that, right? They'll help you weigh your options and what makes sense. Where might permanent establishment going to happen anyway? So it's going to make more sense to build your own branch or subsidiary because of that. They'll be able to guide you in that direction. And I'm going to turn it over to Hazzen.
Great. So I want to kind of shift gears a little bit here because I'm going to speak to the perspective of, Adam laid out good examples of, when you're evaluating perhaps a situation early on and you've got a choice to make as to what path you might want to follow, what makes most sense for your organization based at where you are from a maturity standpoint. I want to briefly just touch on, some of you on the call might come from the perspective that I came into a few years back, and that was a large multinational that had utilized contingent workers, contractors, independents around the world for many, many years without not a lot of controls in place. And you're inheriting a situation where you're being asked to build a program or to mitigate existing risk. That's a tough challenge. You've got practices that have been established, usually driven down at the local level by the managers who are making these decisions in country, in region, in localities. And your challenge is to somehow, understand what risks do we have and put a program in place to help mitigate that risk. And that was the challenge that my team faced here at Ecolab a few years back. And so I just want to walk through a little bit of how we went about it. For starters, I would say, most HR people would know, walking around and trying to advocate for the reduction in compliance risk isn't always the strategy that's going to elicit, the fastest or the most immediate action. And so your business case for why to do this has to be robust and really expand beyond just compliance, as much as that is a real risk. Like I said, it's from a business perspective, it doesn't always elicit immediate action. And so at Ecolab, we tried to take a look at it from a holistic perspective and say, well, when we look at, compliance, not only is it co-employment risk, but, something that the businesses will gravitate to is this idea of the IP risk, the intellectual property risk that these contractors might hold. The fact that some of these might have relationships with key clients or customers, we put the business at risk by having those individuals with that information, that close to our customers, and then also looking at it from the perspective of is there an opportunity to save the organization money as well, right? From simply being able to understand how we're utilizing contingent workers. Are they being provided by staffing providers? Is there an opportunity to consolidate staffing providers? Do we understand what contracts we have in place with those providers? All of that is really where we started early on in our journey. And so we started by building this foundation of looking to, reduce risk and increase visibility. And one of the, probably one of the smartest things that we did was to centralize ownership. Prior to having one person kind of own this space, it kind of lived in a number of places. Whether it was procurement owning the relationships with the staffing providers, or HR, working with managers to find talent, locally in market, and having one team put in place to really try to look and put a program in place, I think was an important step. And then you can start to create your roadmap. And I think the call out here is that it really is a roadmap and a journey that's going to take, frankly, a couple of years, if not a few years, to get. This is not something that really can be solved overnight. There's just so many tentacles that you really have to deal with. But finally, if you do it right, and I think we are doing it right here at Ecolab, there's a huge benefit to an organization. I think that, as I mentioned earlier, because of the talent shortages, there really is an opportunity to create some, in essence, expand the sources of talent, be able to more holistically fish in that talent pool. And from a workforce planning perspective, if you have visibility and you know you're utilizing the gig economy workers correctly, you can really make more informed decisions about when does it make sense to have an employee, when does it make sense to have a gig worker or a contractor or a temp worker, depending on the type of work that's being done. And that then empowers your HR team at the local level to partner with your businesses in a very different fashion than it's being done today. And that's really that's really the journey or the destination that we're trying to work towards at Ecolab. But it's definitely fraught with a lot of compliance and risk, and we partner heavily with whether it's our own internal legal or our partners outside of Ecolab that really help us steer towards that destination that we're going we're trying to go towards. But it boils down to it. I personally think it's an immense change management initiative, especially if it's something that's been in place for a very long time. So with that, I think that concludes the slides that we have, and I think I'm going to hand it over to Diamond, I believe, to go through some questions and answers.
Great, thank you so much. So the first question we have from the audience is, at what point would you consider the PEO model not a viable solution for a company?
Diamond, I can take that. This is Adam. So where it's not viable, again, is if there's a permanent establishment activity in that country, meaning you have to have an inventory and you're storing that in a warehouse or whatever the case might be, that wouldn't make sense because you're going to need to set up your own kind of business entity anyways in that country. Your footprint's going to be heavy there. So that would be one. The other one would be if you have large headcounts in that country. It really doesn't make sense financially and just tax advantage-wise to do that as well. So those are the two kind of areas that I would say it doesn't make sense to go with the PEO at that time.
Thank you. The second question we have from the audience is a PEO responsible for any legal disagreements that may come up?
That's always a tough one. Nina can talk about that, I'm sure, but it really depends on what the dispute is, right, in that given country. But certainly the employer of record, the PEO, is going to be responsible as well. Usually the client or the other organization that is employing that person from day-to-day activity, they're going to be in there responsible as well. Usually it's kind of a joint situation. It really depends on the issue, though. Obviously, if it's a tax issue with payroll or something like that, well, no. The employer of record obviously is going to be more involved in that than the client.
Yeah, and Adam, just jumping off of that, I think that's exactly right. To the extent you have an issue that really is confined within the services that the PEO is clearly providing as the employer of record, and say in the regulatory arena with taxes and the payroll, that will be more clear-cut. Where you get a little bit less clear-cut is if you have a plaintiff's counsel, and depending on whether you're operating with a lawsuit in the U.S. or outside of it, a lot of times they're going to name every entity they can just to try to get to pockets and the deeper pockets, and that's where some of the risk factors that we talked about come into play depending on which statute you're operating under, which statute you're sued under. And a lot of times, those entities are going to be in the lawsuit together, and then you'll have indemnification provisions and other, contractual provisions that may dictate who's going to pay what after the fact.
Yes, well said.
Thank you. The third question we have from our audience is, how fast can a company start utilizing a PEO?
Like I said, within a matter of weeks. It doesn't take long at all because the PEO already is established in that country, and so it's just adding that employee to their existing entity.
Thank you. And the last question we have from our audience is, how much control does company have over the day-to-day activity and the culture of the location that is utilizing a PEO?
You know, Hazzen kind of mentioned this before, and it's important to understand is, you know, visibility and, you know, having the right type of culture, the day-to-day, you know, visibility of that employee. If you're on a good PEO, they'll provide systems that will give you great visibility. And then as far as the day-to-day activity, that is 100% the client's responsibility to make sure that that employee are doing the proper things that they need them to do, right? They act and talk just like your employee. It is absolutely your company culture that's involved there. It's not the PEOs.
Great, thank you so much. Well, that's all the questions we have from our audience. Did any of our speakers have any closing remarks?
Nope, just want to thank our participants for joining us today.
Yeah, thank you very much.
Thank you.
Great, thank you so much. I hope that everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg BNA webinars by accessing our store at www.bna.com/learning. You will currently see instructions on how to earn credit for attending today's webinar. Please go to learning.bna.com to retrieve your certificate. CLE certificates may take 4 to 6 weeks to appear depending on the jurisdiction requested. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I once again thank our speakers and all of you for your participation in today's webinar. Thanks, everyone, and enjoy the rest of your day.